My name is Adam Wolek. I'm a partner at a firm called Taft, Stettinius, and Hollister. Generally just go by Taft like the president. It's a firm, a little over 600 attorneys. We do anything from intellectual property, which is a department I sit in, to all sorts of corporate work for companies, anything from real estate, getting your articles of organization together, structuring your business, to tax, to so forth, many different departments. In intellectual property, I specialize in trademark and copyright law and likeness rights. Do a lot of Computer Fraud and Abuse Act litigation, but predominantly like to work in copyright and trademarks, which is going to be kind of one of the topics of today and how it relates to the gaming industry. There's a lot of rights that overlap that. I will talk a little bit about that after Meredith here, and how I got involved with gaming other than playing Mario Brothers back in the 80s. Recently I've been on the board of VGA Foundation, which runs the Video Game Arts Gallery. Been involved with that from the onset and helped that business kind of navigate a lot of the copyright issues and trademark issues that they faced and help out with some of their other business issues. Meredith?
So I'm Meredith Espino, and I am a privacy and IT transactions lawyer. I just started at a new company called Acuity. Well, the company's not new, it's over 100 years old, but we sell financial services compliance products, terrorist watch lists, that kind of thing. But I focus on IT transactions, which are data licensing, primarily data licensing, software licensing, that kind of thing, but also privacy issues. So I help my client, my company now, and then previously I was at Neil Gerber and Eisenberg, and I help my clients deal with their very complicated privacy issues. I'm a alum of John Marshall next door, so I see some law students here. Hi. So I got involved in gaming. Of course, I play a bit. I'm a casual gamer, but I'm also on the VGA board just recently for the past few months, and also an editor of the Video Game Art Reader. So I edit some of those articles. So yeah, that's me. But let's talk about data privacy. So when people think of data privacy, especially now, if you hear about it, if you know anything about it, people think Europe, they think California. But what most people don't realize is that about half of the countries in the world have some sort of data privacy law. And I'm not going to torture you with going through all of them because that would take years, especially because they're constantly changing. But about 58% of countries have data privacy laws. And some of them are about the same, some of them conflict. And then, of course, the US has their privacy laws. A few of these, I'll go through a few of these. Some of them you kind of only need to know that they exist. The big one is COPPA. So that is the Children's Online Privacy Protection Act. In the US, if someone is under 13 years old, so 12 and under, if you collect their information, there is a whole list of things that you need to do first, and I'll talk about that later. There's the Computer Fraud and Abuse Act, which it started as kind of an anti-hacking statute, but it sort of morphed into other things, but depending on what you're doing, it may not affect you. There's CAN-SPAM. That's more important if you're a nonprofit. It's important if for some reason your game is sending email. I don't know why you would. But for you nonprofits out there, this is important because you need to have certain controls over your emails. So I know it's very popular to send out email blasts to scrape other websites to get addresses so you can send them out. You really can't do that. You need permission to email people. You need to have them have an ability for them to unsubscribe. And if they do request to unsubscribe, you have to do that within 10 days. So there are a lot of rules around that. I'll talk about the FTC in a minute. There's also FERPA, which is the Federal Education Rights and Privacy Act, and that is also for children, but it's for students. So if you're making a game or you have a nonprofit that works with schools, then you also need to be aware that sharing student information in particular, there's a lot of rules around that, and it's extremely limited. So one thing to sort of keep in mind when you're dealing with data, particularly if you're a vendor of someone, so if you're working for a school, if you're a developer working for a company that sells games to, does gamification of training modules or whatever you do, you're a vendor. And as a vendor, you need to be as controlled with your data as your client is. So just because you're a vendor doesn't mean that you can just, go nuts with the data. And hopefully your client will have controls in place and ensure you have controls in place. If they don't, be a little worried. Tell them that, to protect us both, let's make sure that we have contracts in place that protect this data. So for FERPA, if you're working with schools, likely they'll make you sign a contract that says, hey, this is student data, we're a federally funded school. Almost all schools are, even private ones have federal funding. You can't share student data other than, oftentimes it's, name, what school they go to, that kind of thing. And even then, just don't share children data. It's a minefield you do not want to go through. Another law, TCPA. So this used to be just telephone, and which most people don't deal with anymore. Some nonprofits still get calls. So I know WFMT just called me yesterday. But if you're a nonprofit and you're doing phone calls, make sure that you have permission first. One thing that a lot of people do now is send out text messages. This also falls under TCPA. So you need to make sure that you have consent in order to send out text messages. Don't just assume that because they gave you their phone number that's cool and you can just send out all the texts you want. Make sure that you have their express permission before you do that. Also, make sure that there's a way that they can ask you to stop. The easiest way to do that is to either send an instructional text when you first text them saying, if you want us to stop, reply stop. Also have instructions on your website. That's usually the easiest way. The U.S. Patriot Act, which sounds like, why would this apply to me? It's probably not going to. I put it in here because some nonprofits have gotten requests from federal agents for information. That also comes usually with a gag order, which means that you can't tell anyone, including the target of the information. So mostly this will happen to nonprofits. I doubt a gaming company will, a game developer or publisher is going to have this issue, but there have been times where nonprofits have been asked for their membership lists, they've been asked for registration information, that kind of thing. So just be aware that this could happen. If you get it, call counsel. Don't try to deal with this on your own. And if you get a gag order, you cannot even tell the person that the target of the request. And then, of course, there's the Video Privacy Protection Act. If you're, sure.
The Patriot Act, what is it that would bring a nonprofit under its purview?
So agents may be looking for, really they're allowed to ask for anything. So it's really wide open. As long as they got a warrant from the FISA court, they can ask for anything, and the FISA court is notorious for, I think they approved 99.5% of requests from the FBI. So I've heard of, not mentioning names, that they've asked for membership lists. They've asked for registration data, meaning if somebody attended certain seminars, or like today, if an agent is interested in one of you, they could come to us and say, hey, I need to know, were they at your seminar? I want to see their signatures. I want to see whatever. And Ross would have to give it to them and can't tell you that someone was asking. That answer?
Well, I sort of more meant, my recollection of the Patriot Act was that there's a limited set of persons, principally financial institutions, that fall under its purview to begin with, and that you would need to be in some way under that. But
no.
in your head, I may be remembering correctly.
Yeah, no, it's not limited to that. In fact, libraries have been a big, oddly enough, libraries have been a big recipient of agent requests, so they want to know what books people are reading. Apple gets a lot of requests. Facebook gets requests constantly. It can fall under anyone. There's no real limit to who can get a request. That's kind of one of the problems, is that there's no limit. Sure. And then there's also the Video Privacy Protection Act. This act used to have a lot more teeth than it does now. So this act came about, there was a Supreme Court nominee in the 80s, and I think it was the Washington Post got a hold of his video rental list and published it. And he didn't get affirmed for the Supreme Court. So Congress decided that video rental lists should be private, and so they passed this law. This, for a while, applied to Netflix. People thought it also applied to YouTube, but courts have decided, at least for now, it hasn't gone up to the Supreme Court yet, although I think it may eventually. But courts have so far ruled that it does not apply. So, but it's still there. You should still be aware of it. So in addition to all the federal laws, states are also passing their own laws. So as you can tell from all the federal laws, there's no overarching data privacy law. There's no, in other countries, in fact 58% of them, they all have these overarching data privacy laws that protect all of your data. We do not have this. The states are starting to step in, primarily California. So California has a long list. I've listed some of them here. I promise you I won't go through all of them. But California has a long list of statutes that protect privacy. They're fantastic at it. And in fact, they've passed another one called the California Consumer Protection Act. And if you're around privacy, lawyers or professionals in general, this is all they talk about now. This is our topic of conversations, even at parties. So we sleep and think of the CCPA. And what it does is it kind of follows Europe's law, which I'll talk about in a minute, that you have the right to data. You can see what data, if you lived in California, you could see what data a company has about you. You can also ask that they not sell your data. Which in the US is a huge problem because a lot of companies sell their data. That's how they fund their businesses. So if you're in California, you will have the right to say, do not sell my data. Delaware has new privacy law. Illinois' privacy law, one of their privacy laws, is very interesting. It's one of three. Washington also has a similar one, so does Texas. But it's a biometric privacy law. And maybe you guys have heard of it. So anything like your face, your fingerprint, retina scans, your gait, so how you walk, any kind of that kind of information falls under this law. So it's usually done now for employment. If your company wants you to use a thumbprint in order to sign in the morning, that's biometric data. In order for them to be able to take it, they have to get your express permission first, give you notice that they're taking it and what they're doing with it before they're allowed to do it. So there have been a ballooning of lawsuits in the past year or two about these suits for employees. It started when there was a company that wanted you to be able to pay with your thumb, and they were doing it mostly in grocery stores, and the Illinois legislature freaked out, as they should, because this was 10 years ago and there was no security. So, but now it's being used in a lot of other ways. In fact, Facebook's getting sued under this because they are capturing images of faces. So, the tagging feature, that it falls under ILBIPA as well, maybe. And then, of course, Maine has an act. Nevada is just passed a law. Utah has a law that says that they have to tell you if they're going to sell information. And then every state has a data breach law. But I'm telling you all this not because I'm saying you have to follow all of these laws and be 100% compliant. It would be great if you could, but you can't. Only because a lot of these laws conflict, and there are a lot of individual requirements, and they're constantly changing. You will never be able to keep up. And I'm saying this as a privacy lawyer, this is my day. But even I can't keep up with everything. And I'm slightly deranged and obsessed by this. So one of the best ways to sort of handle your privacy situation, and you have to, this is not something you can ignore anymore, this is not something you can say, this is the other guy's problem. If you have personal data, either of your customers or your users or your employees, don't forget your employees, or you're using vendors and you're sharing personal information with them, and by vendors I mean people that help you market, ADP who helps you pay your employees, your benefits provider. All of these companies need to have privacy protections in place, and you need to make sure that they're there. So one of the ways to do that is in your vendor contracts, make sure that they're following certain privacy and data security principles. And I'll let you know what those principles are. So a couple of organizations got together, accounting organizations, about 10 years ago now, and came up with a standard framework that if you follow the framework, you will be mostly compliant. Will you be 100% compliant? No. But this is a really good start. And if you follow these principles, then at least you have a somewhat defensible position when someone comes calling, usually the FTC. Just so you know, the FTC is pretty much the only federal agency that regulates privacy, and even they don't do it that much. You're more likely to hear from a state AG. The state AGs talk to each other. So if you hear from one state AG and you do business around the country, chances are you're going to hear from most of the state AGs. So in order to avoid this, the GAPI principles, we call them. The first one is management. Make sure you have somebody watching privacy. This is not a once and done. You can't just, let's say, okay, check the box, we're done, we posted a privacy policy, we're good. Make sure you have somebody that's monitoring this, making sure people are trained, that it's a sustainable program. Second is notice. Make sure you give your users and your employees notice. Tell them what you're collecting, what you're doing when you collect it, how it's going to be used, who it's going to be shared with, if at all. Of course, it's going to be shared. And if you're going to destroy it and when. Actually, not if you're going to destroy it, you are going to destroy it, because I'm going to tell you to destroy it, but when you're going to destroy it. And then give them a choice, if you can. So this is usually sort of an implicit thing. When you sign up for, when you download an app, it's implied that you consent. Sometimes they're nice enough to ask, but usually not. Other times it has to be explicit consent. So in the EU for cookies, you have to give explicit consent for most of them. And then collection. So only collect what you need. You don't need to collect everything. And I swear your marketing people will say, we need it all and we need to keep it forever. No, practice data minimization. Only collect what you need and ditch what you don't. And then use it how you say you're going to use it. So whatever you have in your privacy policy, use it in that way. If you're going to use it in a different way, change your privacy policy. Let people know. Retain it only for as long as you need it, and then get rid of it. Do not keep data forever. First of all, it gets stale and useless. But second of all, the more you keep, the more you have to protect, the more you could lose. So only keep what you absolutely need. And then when you do dispose of it, do it safely. There was a case in Chicago where one of the payday loan places, instead of, and when they collect information, they collect employment information, social security, all of that. Instead of shredding that information, they were throwing it in the dumpster in the back. So all of those records, so people of course went dumpster diving and got all kinds of great stuff. Don't do that. Please shred things if they're in paper. Otherwise, use software meant to destroy information to destroy the information. And then get a certificate of destruction. That's always a good thing to have. So if something does happen, you have proof that you destroyed it. The next is access. So this is becoming more and more important. In California, you will have this right starting in January, supposedly, that you can see what information somebody has on you. Because it's also allowed in the EU. A lot of companies are doing it globally just because it's easier. So you may have that right depending on the company here in Illinois or anywhere in the country. Also, disclosure to third parties. So if you're going to be sharing the information, first of all, tell people you're going to be sharing the information. Put it in your privacy policy. If you start to share with new people, put it in your privacy policy. If you tell people, oh, we're only going to share with our affiliates, and then you start sharing with third parties, change your privacy policy to tell people that you're sharing with third parties. You don't have to specifically name the parties. Every time you change a vendor, you don't need to change your privacy policy. First of all, no one cares. Secondly, that's too much to keep up with. So just kind of give people an idea of who you're sharing it with, but you don't have to be terribly specific. Security for privacy, this is absolutely vital. So there's a saying that you can have security without privacy, but you can't have privacy without security, and that is 100% true. You cannot have a privacy program without a sufficient data security program. So there are a lot of frameworks that you can follow. NIST has great frameworks and great advice on data security. ISO also has some certifications you can get. Make sure you have an IT person who has a strong security background. Do not rely on help desk for that. No offense to the help desk people who are doing this, but please do not rely on help desk to do your security because that's not their job. Quality. So make sure data is accurate. Make sure it is up to date. You can even ask people to update their information. That's always a nice thing. You could do this by providing a portal or, asking them to update their information from time to time by a pop-up, something, but make sure you have up-to-date information. And finally, monitoring and enforcement. So monitor your program. review your privacy policy every year. Make sure it's up to date. Make sure you're still doing it. Make sure that your employees are trained. Train them every year, not to over collect and that kind of thing. Make sure someone is watching the marketing people. No offense to the marketing people, but they love to share and sell data and share with all kinds of third parties to get all kinds of goodies. Make sure that there's a process in place that they get permission to do this. And if you follow these principles, you should be well on your way to a pretty decent program. For COPPA, it's kind of the same. There are very specific requirements. I won't go through all of them. These slides I think will be available to you. It's kind of the same process, just a little bit more stringent. So if you have kids playing your games and you're going to be tracking their data, and I promise you will, make sure that you're following the COPPA guidelines. So make sure you get parental permission. If a parent asks you to delete their child's information, you have to delete it. If you have to let parents know what information that you're collecting and allow them to see it. So if you've been collecting all their child's chat logs, you have to let the parents see the chat logs. But again, you can read this if you're interested. But finally, just make sure you have an accurate privacy notice. I know that particularly for indie developers and smaller companies, and even some of my clients have done this, which is take someone else's privacy notice, change the name, and post it. You're not helping yourself, and you're not helping your users. So one of the things that gets people in the most trouble is posting a privacy notice and then not abiding by it. That will get you a visit from the FTC. So if you say you're doing something, put it in your privacy policy. Don't put it in your privacy policy and then not do it, right? Say what you do what you say. Yes?
So coming at this from perhaps an indie developer who doesn't have the time, the resources, and I'm going to probably overstate this, but to comply fully or to list everything, especially with the different types of regulations, GDPR, et cetera, do you recommend that they have a more robust, visually appearing privacy policy that maybe isn't fully accurate or is a little bit broad in the descriptions? Or are they better off going with something shorter, straighter, to the point? Because I know that there's been some push towards common language.
Yes.
And yet at the same time, there's so much that can go into a privacy policy that makes it very difficult.
Yeah. I'm always a fan of shorter ones. If I wish I had brought one so I could show you, but I'm very fond of bullet points. So I'll list out all the information that my client's collecting, and I'll just name, address, phone number, IP address, yada, 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 this is what we're collecting. We share it with vendors, and list it out, make it short and easy to read. The most important thing, though, is that it's accurate. If it's not accurate, that's what's going to get you in trouble, because basically you've told people this is what you're doing, and if you're not, that's a call from the AG's office if something bad happens, particularly if you suffer a breach. Then that's going to just be one of the big things that they're going to nail you for. One of the things you can do if you're an indie developer and you don't have time for this, you don't want to do it, it's a lot to deal with, is there's a group called Lawyers for the Creative Arts, and they can get you free help. And they can have, I've done privacy policies for theater groups and others, and I do it for free. So.
Nominal fee. You charge a nominal fee.
Oh, do they? I
Yeah.
thought it was free. Oh, that's so rude.
It's very small, though. I work with them sometimes.
Wow, they do charge a fee? Oh, no, it's
Yeah.
not bad.
It's a one-time fee. It's not bad.
Yeah, but do that. Have counsel look at it and, go through and ask you questions, because laws do change constantly, particularly privacy laws. In fact, privacy laws in California right now, draft regulations came out and it's changing by the hour. So when I leave here, I'm sure there will be a new draft, as I leave. So, talk to counsel about it and pay the nominal fee. God, I hope it's really small.
It's very small.
Okay,
And
good.
I'm actually an attorney. I'm just looking for suggestions for clients that were
Yeah.
maybe even not clients
Mhm.
because they're just not looking for counsel. They're just looking to get
Yeah.
therapy.
I mean, it doesn't have to be so specific that, you know, you're naming all of the cookies that you're using, that you're listing out every single vendor that you have. It can be fairly broad. Just make sure it's accurate. You can't just say we share information with third parties. That's too broad. At least kind of give categories. Categories are perfectly fine. Mhm. Another thing, vet your vendors. Make sure that they have privacy programs in place. Make sure they're handling data properly. Limit your employees' access to data. So if they don't need access to personal data, do not give it to them. And then, I've said this before, obtain express consent before you collect pictures of people's faces, retina scans. I don't know why you do that, but retina scans, thumbprints, that kind of thing. Make sure you have permission to do that. Don't forget about protecting your employees' data. Get rid of data you don't need. And finally, if you have a breach, do not deal with it yourself. Call counsel. So, yeah. Now I'll hand it over.
So with any small business or any type of video game company or frankly any non-for-profit or otherwise, you're going to deal with intellectual property issues. This is anything from trademarks such as the brand name to the company name to the goodwill that the company develops to copyright issues to likeness rights. Other things that I'm just going to touch on at the end real quick is going to be things like how to protect your company through a corporate level. So if you're going to get sued for copyright infringement or trademark infringement, how does it not hit your personal bank account and doesn't go after your personal house or car? And then other things that we deal with, for instance, that we've helped with, like non-for-profits like VGAs, obviously legal issues like leases and so forth. There's a lot of law that goes into businesses. Getting it right from the get-go is a lot less expensive than dealing with mistakes later. A couple of the most important things you could actually do for any business right off the bat is frankly your name. Why? John Madden football. John Madden was a commentator. He doesn't play football and hasn't for the past 40 years. Hasn't coached football for the past 30 plus years. But the rights to his name are worth in the hundreds of millions, if not billions, at this point. Any given name could be bought and sold with that business. Many companies that we know, the simple one would be Coca-Cola. Most of their brand value, most of the company value, lies off two things: their name and its recognition to consumers, and their trade secret, how to make that formula. Now, if another company came up with the exact same formula, it's not going to have nearly the same amount of value or carry as much weight with a company. Why is all of this important? Well, depending on how you choose your name, it may or may not be protectable. Overall, there's various categories of trademarks. There's anything that's called fanciful, arbitrary, suggestive, descriptive, or generic. What does all that mean? Well, we've all heard of Haagen-Dazs. Sounds like a Dutch name and so forth. It's a made-up word. People on the East Coast in New Jersey thought, hey, why don't we create a ice cream company and have a really cool foreign sounding name? It's not even any type of language. That's what's called fanciful. Another example is Exxon and so forth. Arbitrary. Well, Mario Brothers. Why does the term Mario or Brothers evoke plumbers? Why does it evoke a video game? Well, there's no real connection to it. Here's another one, Apple. Why does an apple, a very much real object, evoke computers or software or otherwise? There's no connection to it. Now, these are extremely strong trademarks. The more abstract, the more arbitrary, or if better yet, fanciful, you made up the word like Exxon or Haagen-Dazs, the stronger your trademark. Anybody comes close to having something that's similar is going to be a lot more likely to be found to confuse your brand. What does that mean? You have more protection for your brand. You could keep more people away. Ultimately, if you have consumer recognition, that's going to bring you a lot more value. Now, things like John Madden for football, that's suggestive. Now, do you think of video games when you think of John Madden? Now you do. 20 years ago, I wouldn't have thought of, I would have thought of the commentator or maybe former coach John Madden. But when he put his name on a game, it definitely suggested that it could have been a football game. That's still a strong trademark, but it's still bordering on the protection. The thing is, he had a lot of brand recognition that made up for it. Descriptive is something like American Airlines. Well, what is it? It's a airline company that may be in America and so forth. Now, that in itself is extremely vulnerable and doesn't carry as much weight. But because of their brand recognition, the amount of money that they spend advertising it, the fact that they sue everybody who comes close to their name, they've developed a lot of strength with it. But that came at a very high expense and a lot of years of using it. Now, there's also things like generic companies or genericide. A lot of people don't know that elevators were a trademark. Saran wrap, we use it pretty generically. And there's a whole host of terms that ultimately could fall into that. Now, the goal for any company, though, is not that you're going to hit any one of these extremes, but the more extreme, the better. As long as it's more arbitrary, more fanciful. Create a name, do some research that nobody's using anything similar in your area. Now, does it mean if somebody's using a name in another industry, I can't use it? Absolutely not. Apple, right around $900 billion company, sometimes up to $1 trillion in market cap. Largest company in the world, exceeds most countries' GDPs. Well, there's Apple Vacations. There's Apple Trucking. There was an Apple Music label that was going to block Apple from using Apple on iTunes. Now, it took a 9-figure payout from Apple to acquire that company, but just because the point is another company uses your name in a completely different industry doesn't mean you can't use it. That's one thing that I see clients get wrong all the time, and that is something just to be aware of. Now, that said, if that company could potentially expand into your industry and consumers could potentially foresee them using that type of industry, that type of product, well, that very well may put you in danger. You want to make sure that your company is completely clear of that. Now, copyright issues. This is something that we advise, VGA on, I advise companies all day on. Now, this comes in many ways. Let's say you're using an independent contractor to code your software for your game, your website, your product. Okay. Without a written contract assigning that to you, they are actually the owners of that software, not you. Under U.S. copyright law, the author of the product is the owner, unless, one, they're an employee, and there you have to button that up. Do you pay them W-2s? Do you give them benefits? Do they come in regularly? Do you supply them, their computer and so forth? Or two, much easier, written assignment with any type of contract. Hey, I will pay you X amount of dollars. Have an IP transfer clause. You know what your intent is. They know what the intent is. Nobody's going to object putting it in writing. And it could be just as simple as including it in your contract, your vendor contract. But it needs to be in there and it needs to be in writing. Now, let's say you forgot to do that. This could be retroactive. Of course, if they get wise to it, they may not be willing to, and you can't force them to assign it, other than not giving them future work. But you could always make it retroactive. The other thing that relates to video games is it's not just the copyright in the video games or the software code. Well, what else is there for copyright? Well, the characters, the story, the theme of the game. Let's say somebody takes a video of themselves playing the game. Well, they're technically copyright infringers. Why? They just created a derivative work of something that you own a copyright on. Let's say somebody takes a screenshot of that game. Well, that screenshot is also derivative work. Now, do you have to enforce all of these rights? No, of course not. You could choose to, selectively. Unlike trademarks, you don't have to police your copyright. Many video games choose not to. Why? Because they could add more fan base. They could spread word. You know, they really like that. But let's say somebody starts taking pictures of this and starts trashing your game and so forth. Well, you could also potentially use it to squash various other distributions. But you could squash other copycats as well. Let's say you use photos within games. Like, well, I created this game, you know, I have a license to this photo. Yeah, but do you have a license to distribute it to 100,000 people, 1 million people? A lot of times those licenses for photos are very restricted, and their uses are very restricted. And oftentimes the number of people who view that is restrictive. Well, here's another one. Represented clients in this area too, including in lawsuits. Music. Embedding music in a video game. Well, I got a license to it. Well, what kind of license did you get? How many seats were you permitted to distribute that song to? I mean, my client's music is sold for 99 cents per song on iTunes, but you distributed it to 1 million people. Did you pay them $1 million? You know, did you get the proper license for to use that type of music? I mean, all of a sudden, if you're a developer and you start infringing on some of these rights, not only do you have to worry about, well, I only had about 5,000 people play this game, it's an indie game. What about statutory damages? That could be, you know, 150,000 per instance. You could pay their attorney's fees. So they could sue you, and then you have to pay their lawyers on top of yours, and potentially pay the statutory damages. That could add up very, very quickly. And that's something that a lot of people, frankly, just take for granted. What about likeness rights? All of a sudden, now that's a little bit more intuitive. You start using characters that maybe other people have previously used, insinuated, characters from other worlds, or real-life people. All of a sudden, you're implicating somebody else. Now, are there sometimes exceptions to all of these, like fair use and so forth? Yeah, but fair use has various factors that you need to meet. It's pretty strict, it's hard to get, and frankly, the only time you're going to say fair use is after you've been sued. So first you have to, you're going to get sued, you're going to have to expend a ton of money on lawyers who actually know what they're talking about to be able to wield a fair use defense. You're going to spend, maybe hundreds of thousands of dollars on those lawyers to defend you. You're not going to get your attorney's fees on a fair use, in all likelihood, defense, only to be able to use a character you could have swapped out in the very beginning. So these are all principles that every game developer should take into account, frankly, any business. Well, here's another one. Let's say you come up with an indie game and it takes off. You don't have the capacity to scale up, make a bigger world, make follow-up games fast enough, and you want to license your rights. Well, likely these larger companies aren't going to care about your code as much for a game. What they're going to care about is the world you created, your copyright, your characters, again, your copyright, likely your brand, so your trademark rights, and these are the type of things that you license. Ultimately, if you're fortunate enough to be in that position, you could be licensing it to larger game companies and potentially movie studios. We've represented small companies while their games haven't been necessarily, in some cases, very, very well received by the public. In other cases, we have very large contracts for them with movie studios simply based on future movie rights. Now, their games haven't taken off yet, but these movie studios sometimes want to take that bet. Could pay $1 million now versus $500 million or $200 million licensing rights later. They're willing to put that in. So these are all things to potentially consider. But it all starts with protecting your intellectual property. Why is it important to get it early? Well, with trademark rights, the sooner you file that trademark application, even if your game hasn't been released yet, you could have an intent to use application. You basically save your place in line for your game. So you could extend that trademark for up to 3 years. If you're fairly certain you're going to release it in 3 years, hold that name in place. That way it keeps everybody in bay from using it. If you're developing that game, either before publishing it or right when you publish it, file with the Copyright Office. It's a few dozen dollars. It's, I believe, $45 now? $55. Yeah, it changes often. But still, a marginal fee to protect your rights. Why is that important? I could just file a copyright registration later, you may think. Well, if you don't file it within 1 month of somebody ripping it off, or 3 months of its publication, you don't get a chance to get your statutory damages. No more attorney's fees. So do it quickly in the process. Why is that important? Well, I'll tell you. Let's say you don't have the money for a lawyer, but you're talking to a lawyer. Hey, I have a copyright registration that was filed timely. They know that if they're successful, wow, you do have a case. They could get their attorney's fees, makes them feel comfortable. They may work for free. Well, for the attorney's fees that they ultimately get. And 2, statutory damages. That's per instance. That's a game changer in litigation. If you sue a company and they know that there's attorney's fees and statutory damages, I could tell you from many years of personal experience in this, it is a very, very different negotiation. Does that mean that your copyrights aren't valuable? No. But you may have to pay out of pocket for an attorney, or you get a contingency agreement, and then rather than getting those multiple millions of dollars in a settlement or in a judgment, that might get cut in half by the contingency. Maybe you'll only get 60% rather than the 90 some odd percent you would have otherwise got. That's real dollars. So in short, keep in mind your trademark rights from a very early time in your company. Keep in mind your copyrights, file them timely. Now, it's not just on the game, but what else could you copyright? Copyright your manuals. Copyright your web pages that advertise the game. File for all of that. All of it's protectable as long as you're one of the original authors of it. The only requirement for a copyright is originality, and you put it on a tangible medium. So for instance, this video right now, the second it hits It's probably not a cassette tape, but some type of storage device, whether, SD card or whatnot. Once it hits that tangible medium, like saving it on a computer, it could be copyrighted. So the second you save that web page or publish it, file for that copyright. And then finally, be aware of likeness rights. If you're using a person that exists, be very, very wary of using that person without their express written permission. Get it in writing. If you would like to contact me or have any other questions about this, I'm happy to pass around kind of a PDF of and PowerPoint of do's and don'ts of trademark protection. And if you have any questions, I'm always happy to answer them. Thank you. Do we have any? We have a few minutes, I see, for some questions. So if anybody has any questions, we're very much happy to answer them now, or you could find us shortly after, for a few minutes after the program.
Can you talk more about the trademark of a name that's more generic?
Mm-hmm.
So like Facebook started as the Facebook, which
Sure.
doesn't sound like it's very, I don't know, protectable, but what happens in the case that,
Yeah,
it's
so,
that name and then somebody else does something similar who wants to use that name?
so think about it before you knew of Facebook. If somebody said Facebook, I would have thought maybe my, my high school classmate book or something like that, right? I wouldn't have thought of something that's online. I wasn't aware of any website that was online by that name. And at the time, it wasn't generic. It's become so commonplace that we all know it. But the difference between Facebook being generic and well-known is you don't think of any other type of social media website as Facebook. You think of one company, one webpage, or maybe app as Facebook. So you know the exact origin of that name. I think of something like elevator. One elevator from another. I don't know, which company develops that. I don't think of an origin. I think of the product. And that's more genericide. Is it the product? Or is it a specific company or origin? One thing, a good example, though, right to your point, is something like Google. Google struggled for a long time with fighting with companies that, hey, you're not doing, you're not Googling this. You're performing an internet search on Google. We're a company, we're a service. Now their brand recognition, and it has been for quite some time, is nobody thinks of going on Bing and thinks of Google. But at the time when Google came around, they were the minor player. They quickly took off because of the service that they provided was found to be advantageous to consumers. But at the time, you had SGs, you had Yahoo, and various predecessors. Netscape had their own search program. Alta Vista. I'm bringing it back. Excite. So, those companies, though, spent an enormous amount of money fighting that. But Google is actually not a fanciful name. It's actually a numeric number. So it's technically arbitrary for it. It's clever. But it is an arbitrary name. So it is strong. They had a very hard uphill road to go to become generic. So it's a lot easier to become generic if your name is more descriptive. But they did a hell of a job protecting it, and then they became so big that nobody really confuses them with anybody. But great question.
Anyone else? All right.
Okay, thank you.
Thank you.